full information regarding this current and other tenant documents. This is the landlord tenant or summary proceedings document, and you are here for a pre-trial. Your landlord has made allegations and claims that you should be evicted because you have not paid your rent or because they seek termination of your tenancy for a lease violation. After today, you will come back for an additional hearing or trial of the case unless you and your landlord reach some agreement. In these proceedings, you have the right to have your case heard in proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Ann Arbor and County Township is covered in this court. You also have the right to demand a trial. If you want a trial by jury, you must demand it orally at the first appearance, or in writing 5 days after the first being advised of these rights and information. Jury fee must be paid when the demand is made or within 5 days after first being advised of these rights. Right to rental and other housing assistance. 5 days of first receiving these advice and rights and information. You must provide written proof to the court that an application for assistance has been submitted for processing. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mich.gov. Assistance may also be obtained by contacting Housing Access for Washington County, commonly known as HAWK. HAWK can be reached at their phone number, area code 734-961-1999. Additional assistance is also available through Washington County Veteran Services. Their phone number is area code 734-973-4540. Also, you may obtain housing assistance and other resources through coordinated entry resources. Their phone number is 734-54678. You do not need a judgment to obtain assistance from any of these agents. SovCit complaint are you have a right to reach an agreement outside the court. The Michigan and local community dispute resolution programs are a possible resource. Washington County Dispute Resolution Center can be reached at their phone number of area code 734-794-2125. To protect your credit and future rental possibilities, your case may be resolved by way of conditional dismissal in lieu of judgment, if that is approved by all the parties in the court. It is important that you understand these rights. If you have any questions, please feel free to address the court during your hearing.
That's cool. I want to go there.
Yeah, and yeah, it's that.
Oh, turn the beat up in Vaughn's dictionary. We ain't spelling right tonight. Nah, we spelling wrong. Step in the courtroom. words all twisted. Sherrick Vaughn speaking like logic got evicted. Mirandarization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compellment too. He reiterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a moot point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew, but the only thing recused was his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like his courtroom thunder. Fired his lawyer, then begged for a hand. Elbow counsel stuck like, bro, this ain't the plan. He's pro se, no way, thinking he's slick, but he's playing Uno while the court plays chess quick. Every motion's a joke, every word's a crime. Even Dr. Seuss said, man, that rhyme don't rhyme. Requise, recruise, make up what you choose, but every fake word just adds to your blues. Mirandarize this, moat point that. Sherrick Vaughn rap dictionary looking flat. It's a moat point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew, but the only thing recused was his brain from the view. Mirandarization, unlogical station, compellment nation, courtroom clown in rotation. Yo, turn the beat up in Vaughn's dictionary.
Right, grab a White Claw. Settle in today, we got a true legal scholar on the docket, a pro se defendant who's about to teach us all a lesson, though. Probably not the one he intends. A flurry of fallings land with a thud. Got a judicial notice to muddy the mud. The judge looks confused by the arrest of judgment. While our pro se scholar files a motion to squash the whole punishment. The state didn't write back. It's a legal disgrace. And without Mirandarization, he's closing the case. He says, Your Honor, the logic is sound and astute. It all stems directly from a poisonous root. He's serving up his tainted fruit. The fruit, the tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. The state calls their witness Corporal Javin so calm. Tales of the threats and the verbal napalm. I'm a threat for a reason. He said with a glare, then a scholar on cross-exam says hold it right there. To prove that this tree has been poisoned for good, let's play my arrest video, it's misunderstood. Oh geez, here we go, he's playing the tape, he's literally handing the prosecution the very fruit.
Oh, I'm sorry, it told me to unmute.
No, wait, you love to see it. The body cam rolls a spectacular own. The seeds of his legal demise are now sown. Citing Pennsylvania versus Men's with a confident shout while refusing for 8 straight times to even get out. When your jaw gets broke, it's gonna be your fault. He's proving the state's case without any halt. He's showing the jury with his own evidence the very fresh fruits of a brand new offense. He's serving up his tainted fruit. The tainted fruit. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. Then he calls to the stand his one saving grace, his baby mama to plead his whole case. Tell the jury he asks her if you be so kind. Am I the retaliating, threatening kind? She swears on the stand he wouldn't hurt a fly. A claim the prosecutor's quick to deny. Now ma'am, about that aggravated robbery. He thought to praise his character and opened up the door for the jury to hear of the crimes he'd done before. And the jury comes back guilty, unanimous. He showed them the video of the crime, opened the door to his priors and based his entire defense on a mispronounced legal theory. He served the jury his own tainted fruits on a silver platter. In the end, it was just a fallacy of a mismalice of justice. grab a White Claw. Settle in. There is no scandal at Law Talk Nation. You can only play, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got preacher on the dial, planning always make your chest smile. The pros say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day on Law Talk with Mike.
The 14A District Court, Washington County, State of Michigan is now in session. All those having business before the court draw near. Honorable Judge J. Cedric Simpson presiding.
And good morning. Why is my that's not sure why that's doing that. Good morning, everybody. Court does call the case of Casey Zhang versus any and all occupants at 383 Sedgewood Lane.
Your Honor, Mohammed Zahir, pin number 5, when he came for the private.
Good morning, Your Honor. My name is Kelly Ruddock. I'm here.
Okay. Do you live at Sedgewood Lane?
Yes.
Okay. Is Casey Zhang here?
No, she's my client, Judge. I represent the plaintiff.
Okay, I got you. All right. So this is a termination case. Was there a lease?
According to my client, there's no lease.
Why is this case in the name of any and all occupants?
I don't think my client knows the name of the defendant, Judge, who lives in there.
Well, that's a problem. You need to talk to your client more because I have a lease. You guys attached it from 2019 that Ms. Ruddock is listed as the occupant. As the leaseholder.
But the lease expired, Judge.
Okay. I get that may be the case. But I'm asking, why is this listed in any and all occupants? You're telling me that she doesn't know who is there. That's not true.
Then I will check with her, Judge. Is there any way we can have conversation with the tenant, Judge? in the breakout room.
I don't do breakout rooms, but you're more than happy if she wants to talk to you, she could do that. Ma'am, you are entitled to seek an attorney. I will give a 1 week. Actually, it's going to be a 2 week adjournment, correct? It's going to be a 2 week adjournment for my next available date in this matter. And I'm just going to ask you, Mr. Riddick, so that I can, was after 2019, was there another lease signed?
Yes, Your Honor.
Yes?
Yes, Your Honor. Yes.
Okay,
Your Honor.
let me ask you this. Do you believe that you're under a current lease?
Yes, Your Honor.
Ma'am, if you wish to speak to the attorney, his number is listed on the complaint. You're under no obligation to do so. You can actually hire your own attorney to defend you in this matter. I will adjourn this matter to October, what is it? 24th. October 24th. Uh-oh.
What time, Judge?
Something happened. Hang on a second, sir. Somebody's doing something. Got it. October 24th, 2025 at 3 p.m. That is an in-person hearing. Both sides need to be here in person. We'll resolve it then, or try to. Okay?
Thank you. Thank you, Judge.
Thank you, Your Honor.
Thank you. Covington Apartments versus David Chambers IV.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Do we have him?
We do not.
David Chambers? No response. Did not check in. You paid for second service. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right, go ahead.
Your Honor, this is a non-payment of rent case. Rent to retain is $850. Their court cost of $173.20 for a judgment of $1,023.20. This is a possession-only judgment. Upon information and belief, Mr. Chambers is an adult, is not in military service, is otherwise within the jurisdiction of this court, and this property has been kept fit for the use intended and in reasonable repair.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Thank you.
Covington Apartments versus Latasha Hamilton.
Rebecca Austin.
Good morning.
Go ahead, counsel. Say.
Rebecca Austin for plaintiff, Your Honor.
All right.
Latasha Hamilton.
And the Hamilton and also, is it Deneva Massey?
Yeah, Massey's not available currently.
All right. All right. What is plaintiff's claim in this case?
This is also a non-payment of rent case, Your Honor.
All right. How much is owing?
Past due rent, the amount of $1,651, Your Honor, court cost of $216.40 for a total of $1,800, $1,867.40.
All right. Ms. Hamilton, how are you guys intending on getting this paid?
I have the payment. That 15 is the new charges as of October 1st. When I paid the rent the same day. I have the rental payment. Those are the charges as of October 1st. Yes. I paid the rent last month, and the same day that I paid the rent is the same day that they send me to court. So I do have the rent and my late fee. I'm working on the court costs.
Okay. So how much can you get paid prior to the next hearing date?
$1,650.
All right. Pay $1,650. Try to get those court costs. When can you get that $1,650 to the landlord?
By days in.
All right. What I'll do is I'll indicate Monday's a holiday, so by the 14th, pay that by October 14th. All right. Work on getting those court costs in. If you get those court costs in, then this matter can be dismissed. But I'll October 24th, I'll adjourn it to October 24th, 2025 at 3 p.m. Okay?
Okay, so if I have my court costs, if I have my court costs in before then I still come to court or no?
You don't need to come to court if they're going to dismiss it, but you got to make sure you got everything paid, all court costs, late fees, everything. If you're sure that everything's paid, then you don't need to appear. But otherwise, you need to appear at court.
Okay, sounds good.
All right, thank you.
Thank you
Covington
so much.
Apartments
Have a good day.
versus- You do the same. Covington Apartments versus Doris Joyner. That matter's dismissed on plaintiff's motion without. And was that it for you, counsel? Or-
Your Honor, have a great weekend.
You do the same.
Thank you.
Court does call the case of Dave Pata versus Seth Barton.
Morning, Your Honor. Paul Fuster on behalf of plaintiff David Pata.
Seth Barton.
Yes, sir, Your Honor.
All right, there he is. All right. This is a non-payment of rent case. This is, I have it. How much is owing?
$8,000 in back rent, not including $25 a month in late fees.
Say that again.
I'm sorry, you're $8,000 in rent, Your Honor.
$8,000. What is the plaintiff's entire claim? 8,000, and you're talking about late fee. What is plaintiff claiming?
We just want the $8,000 and we want possession, Your Honor, essentially.
Okay. Sir, do you dispute the amount that's owed?
Yes, Your Honor, the house has been unlivable since May 28th. A pipe broke in the basement, rendered the mechanicals non-functional. There's no hot water in the house. There's no furnace operating in the house. There's no water softener system in the house. The house is being filled with mold because of water intrusion. Nothing has been done about it. There's been an insurance claim that's been ongoing that has just now been finally starting to come to fruition here over 3 months. The house has been inspected by the city. It was deemed to be condemned status. He should be being paid loss of use for rent from his insurance company due to his claim on the insurance.
Stop, sir. Counsel, you know anything about any of this?
Well, we know that there was water damage to the house. We've tried to get in there and remediate it as much as possible. And it's my understanding that Mr. Barton doesn't even reside there anymore. He has a new residence. It seems that he's basically just using this as a storage facility at this point. He told my client that he would have been out last month. We filed this basically as a safety net to make sure he got all his stuff out of there, but he has not.
If I may speak, Your Honor.
Mr. Barton, I'll need a written out. No, I need a written answer to the court. I think I have a picture of what's happening here or what may be happening here. I need a written answer to the court. You'll need to file a written answer to the complaint. You'll need to do that by the 17th, 1 week out.
Yes,
I'll set a hearing in person October 24th, 2000.
Okay, I can't find the comment in the chat, but because I want to credit you, but no, I did not see Stacy Hines' hair. What is going on up there? What the hell is going on?
25 at 3 p.m. That is in person. Both sides need to be here in front of me.
Thank you, Your Honor.
Yes, Your Honor.
Thank you. Your Honor. Court calls the case of Arbor Club versus Sade Kayo Ankapong.
Good morning, Your Honor. Sidney Katz on behalf
I
of
mess it up every time. Good morning, Mr. Katz.
Thank you.
Kayo Ankapong, they are not here. If you'd like to take a default, raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do, Your Honor.
Go ahead, sir.
Your Honor, this is a non-payment rent possession case. To the best of my knowledge, the defendant is not in the military and minor are unable to stand trial. To the best of my knowledge, the property is being kept habitably. Currently, there's a balance due, including court costs totaling $2,973. That's $2,973. Requesting a default judgment in that amount with writ to be issued after October 20th.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Six Trails versus Jacqueline Rowe.
Morning again, Your Honor. Sidney Katz on behalf of plaintiff.
Jacqueline Rowe, no response. You may proceed.
Your Honor, this is a non-payment rent possession case, second mailing by the court. To the best of my knowledge, defendant is not in the military, a minor unable to stand trial. To the best of my knowledge, the property is being kept habitably. Currently, there's a balance due, including costs of $1,542. That's 1,542. Requesting a default judgment in that amount with the writ to be issued after October 20th.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with writ to issue in 10 days. Willow Ridge Apartments versus Angela Smith.
Pulp Fiction reference early in the morning. I love it.
Smith.
Did it work?
Yep.
Okay.
You're Angela Smith? Okay.
Yes, sir.
What is plaintiff's claim?
Your Honor, there's currently a balance due, including costs at this time of $5,797, or I'm sorry, $5,787.
Ma'am, how do you intend on getting that paid?
I just cashed in some stocks, and so I'm just waiting for that money to come back so I can pay it off.
So, all right. So you cashed in some stocks and you're waiting for that to pay out, and then you're going to pay the amount owed?
Yes.
Do you have an approximate time as to when you're going to receive those funds and pay it?
It just says 7 to 10 days.
Okay. So when did you do it? I'll count the days, but
yesterday. So
yes,
not long ago.
All right. No, that's okay. If that's what
assuming
you're
the
telling me.
24th should be safe, Your Honor.
Yeah. So what I'm going to do, ma'am, is I'm going to adjourn this out to October 24th to my next available date, 2025 at 3 p.m. That's an in-person hearing. But if you have everything paid by then, and just make sure to double check them that you got everything paid,
it sure is.
It's likely going to be a dismissal and you won't need to appear.
Okay. Thank you so much.
All right. Thank you. Court does call the case of Willow Ridge Apartments versus, is it Berhanu? Is it Abdella?
Morning again, Your Honor. Sidney Katz on behalf of plaintiff.
Say he's here. Yes. Abdella? Oh, I see him. Can you unmute, sir?
Yes, I did, Your Honor.
All right, there you are. All right. What is plaintiff's claim in this case?
Your Honor, currently there's a balance due, including costs totaling $3,296.
All right. And sir, how do you intend on getting that paid?
Your Honor, I already make $1,200 from that. So the balance I have 2,000 some. So I'm trying to pay next week by 17.
By which day?
October 17, next week.
All right. You'll have everything paid?
Yes, I paid 1,200 already.
No, I heard you. But you'll have, so they'll credit the 1,200 you say you paid, and you're going to pay the balance by the 17th.
Yes, Your Honor, that's correct.
All right, I'm going to put that in file that the balance is going to be paid by the 17th. I'll adjourn this out to October 24th, 2025 at 3 p.m. All right, that's an in-person hearing, but you don't need to be here if everything's paid off. You just have to make sure to check with your landlord to make sure everything is paid.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
Thank you. Willow Ridge Apartments versus Steve, is it Inzumba?
Good morning again, Your Honor. Sidney Katz on behalf of plaintiff.
Inzumba?
I'm here, sir.
No.
I'm here.
Where? You're right there?
Yeah.
You got him. All right. All right. What is plaintiff's claim in this case?
Current balance, including costs, $4,067.
Sir, how do you intend on getting that paid?
Oh, I want to pay before November, because I have just the problem. I work just by myself. My wife not working, so he worked just last week. So I want to pay this Monday. I want to pay 1,500, and after 2 weeks I want to pay 1,500 again. Before November, I want to finish.
You're going to pay 1,500 by this Monday?
Yeah, Monday.
And then when would your next payment be?
Next payment before 2 weeks. I want to pay again 1,500 again. And I want to finish this balance before November.
I hear you. You'll have to work something out with your landlord or with the attorney for the landlord. I will adjourn this. You need to pay the 1,500 by the 14th. I will adjourn this out to October 24th, 2025 at 3 p.m. If you can work something out with them, that's fine. Otherwise, you need to come to that hearing in person and we'll deal with how the balance is going to get paid.
Okay, sir.
All right. Thank you.
Thank you, sir.
Thank you, Your Honor.
And I think the rest of yours, let's see, Arbor Club versus Jones, Arbor House versus Meyer, Arbor House versus Brian Montgomery, Arbor House versus Perez, Arbor House versus Rodriguez Ramos, Six Trails versus Pierce, Six Trails versus Fritz, Six Trails versus Thompson. All of those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor.
Thank you, sir.
Have a good day.
You do the same. Group 5 Management versus Winston Johnson.
Morning, Your Honor. Robert Weiss appearing on behalf of Group 5. Always good to see you.
Good seeing you, Mr. Rice. What'd you say? Winston Johnson?
Yes, sir.
Okay, there you are. All right. And I need a sticker now. What is plaintiff's claim in this case?
The amount owing is $2,853.42.
Give me that number again. Go ahead.
Oh, excuse me, 2853.42.
And is that including cost?
It does, Your Honor.
All right. Sir, how are you intending on getting that paid?
I can pay that next Friday when I get paid.
The 17th?
Yes.
All right. So what I'm going to do is I'm going to indicate defendant to pay the balance by the 17th. I'll adjourn this out to my next available date, October 24th, 2025 at 3 p.m. That's an in-person hearing. If you have everything paid, you can double check it with Mr. Weiss or your landlord. If you have everything paid, I don't need to see you. Okay. But if everything's not paid, you need to be here in person.
Sounds good.
Thank you.
All right. Thank you. And Group 5 versus Burnett. Is it Turvington? That matter's dismissed on plaintiff's motion without prejudice.
Have a nice weekend, Your Honor.
All right, you do the same, Mr. Weiss. Court calls the case of Arbor Meadows versus Katrina Robb.
Hello, Your Honor. This is Katrina Robb.
All right.
Good morning, Your Honor. Gabriel Lacey for Arbor Meadows.
All right. What is plaintiff's claim in this case?
This is a termination of tenancy file, Your Honor. So it's a just cause termination where our claim is that the tenant is in violation of the community rules and regulations by failing to maintain the exterior of her home site in accordance with the rules, including but not limited to failure to maintain landscaping, trees, and bushes, failure to maintain the general clean appearance of her home site. And she's received notices regarding these violations and failed to cure them.
All right. Ma'am, what is your position on this?
I have, I believe I've cleaned up the property for the most part.
Okay, so you believe that you're no longer in violation is that a correct way to sum it up?
I can show you the property. So.
Well, I don't need to see it now. I don't know that I can put a reference on it, even if I could see it at that point, but thank you. But you believe that you've done everything.
I'm physically able.
Okay, let's do this. Are you going to need help in terms of an attorney or something like that to understand exactly what you may need to do?
That would probably be beneficial.
I'm sorry, I didn't hear you.
That would probably be helpful.
Okay, so there were numbers provided to you at the video at the very beginning. You can contact legal services or the Michigan Clinical Law Program. And they may be able to assist you in this. Okay? Ms. Rob?
Yes. Okay.
Okay, did you hear me?
Yes.
Okay. So I'll give you time to do that. I'll adjourn this out to October 24th, 2025 at 2 p.m. Those are in-person hearings, so you'll need to be down here at the courthouse, okay?
Okay.
All
Yes.
right. Okay, thank you.
Thank you.
Court calls the case of Arbor Meadows versus Akiko Fujimaki.
Gabriel Lacey for Arbor Meadows.
Yes, he is Mr. Stringer.
Good morning, Your Honor.
Good morning.
I am Akio Fujimaki. I live at Arbor Meadows.
All right, but you have an attorney, Mr. Stringer? Is he here?
Yes, but I assigned yesterday, and I came to the court to adjourn because he's not available. He can't make it today. So,
Ms. Lacey, did you get a copy of Mr. Stringer's appearance?
I did, Your Honor.
All right, very good. Since defendant has counsel in this case, I will adjourn this out to October 24th, 2025, 2 p.m. That is an in-person hearing, so let Mr. Stringer know that.
Thank you, Your Honor.
Okay? Thank you.
Thank you.
Tenant has two cases.
Court calls the case of Arbor Meadows versus Milton Rice. I have two cases for him. Not sure why that is. And on the other case, on one case, it's just him alone. On the other case, there is also Leah, is it Munguia? Reyes, Munguia.
Hola.
Okay, who are you?
Míralo, míralo. Hablemos. Hola.
Hola, ¿habla inglés?
A little. No, no mucho.
Okay, un poquito. All right. We may need.
I need
it.
October 24th, dígale.
We may need an interpreter.
Hello, sir. Hello.
I need you, first of all, you have to stop the vehicle. I can't hold the hearing while you're driving.
Yeah, I need for 24 for pay every rent. October 24th.
I need you to stop the vehicle.
Okay.
Otherwise, I am not going to hold the hearing. I don't know why I talk slow. I don't know that that helps you understand what I'm saying, but I'm not going to hold the hearing while you're driving.
Okay.
I'll pass it. I'll recall the case.
Okay. Thank you.
Court calls the case of Arbor Meadows versus Elizabeth Cornelius and Michael Cornelius.
Yes, Your Honor, we're here.
Oh, they got both of them? Okay. All right. This is a non-payment of rent. How much are you claiming?
Thank you, Your Honor. At this time, the outstanding past due rent is $1,900.01. Court cost of $214. Total outstanding balance is $2,114.01.
$14.01. All right, folks, how are you going to get that paid?
I'm pulling money out of I work for the VA in Ann Arbor. I'm pulling money out of my TSP and I can't do it till the 16th.
Okay.
of next
So-
week. And they're doing the reorganization right now, and I'm not actually sure what's gonna happen with everything at this point, but I am pulling money out next week.
So you're telling me you're not sure what everything that's going to happen because of the government shutdown and what they're doing?
Correct. And my husband, Michael, lost his job, but he did get a new job. He's just waiting for clearance right now of his background check and stuff for Amazon.
Okay. All right. So
I should be
Here's-
able to
here-
pay it. Once
Go
I
ahead.
once I request the money, it takes like 3 days to process it, and then I have it directly deposited. So I'm hoping by the week after, like that Monday or Tuesday after.
So you're hoping that the federal government is going to do something on time? Never
No,
mind.
I'm
You do not have to answer that. You do not have to answer that. That was my statement.
I can't answer that.
Never mind. Never mind. That just doesn't need an answer. Here's what I'm going to do, folks. I'm going to adjourn this to the 24th, 2025 at 2 p.m. Okay, that's an in-person hearing. Okay.
Okay.
And if you've got everything paid, you don't need to be here. If it's not, you'll need to appear in person. Okay.
10:25 at 2 o'clock.
Yeah, 10:24
10:24. Okay. Thank you
at
so
2
much, Your
o'clock.
Honor.
Thank you.
Have
And
a
I
good
know
day.
I know it's a scary time for government employees.
It sure
You're
is.
you're in my prayers. All
Thank you
right.
so much.
Thank you. Court calls the case of Arbor Meadows versus Don Ho.
Gabriel Lacey for Arbor Meadows.
Yes. She what? Court calls the case. I'm not talking to her. I realize you shut the video, but I'm not talking to her either. Court calls the case of Arbor Meadows versus Charles Carter.
Gabriel Lacey
And-
for Arbor Meadows.
And also Julius Rutledge II.
That's Mr. Carter.
Mr. Carter.
Good morning, Your Honor.
Okay, there you are. I got you. I had to just pick you up on my screen. All right, what is plaintiff's claim in this case?
Thank you, Your Honor. We've actually entered into a consent with this one. It was a termination of tenancy based on the maintenance of the unit. Wait, nope, that's not what this one was. Hold on. It was a termination of tenancy based on the tenant's account having failed to pay rent timely for 3 times or more in a 12-month period. We've entered into a consent judgment regarding this.
I don't know that I can enter a consent today with him being unrepresented.
Okay.
But Miss Lacey, we're gonna potentially have an issue. And can you put Miss Lacey and myself into a breakout room, please?
Yes.
Everybody, please hold. The court's going to just go into brief recess.
Did I miss it? Did I miss it? What? I'm told that Ho took a shower. and but I might have missed it.
Ma'am, are you a whore? I object to the relevance of that, Your Honor.
Can I say the words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
You're now our jury, so I'm going to give you a set of instructions in a few moments, but those instructions will include, don't discuss this case, don't talk about what it's about, don't try to hypothesize what you think the evidence will be, talk about anything you want to except this case right now. You should not let anyone else talk to you about it as well. If you were to leave out to go outside to smoke or something like that, the bailiffs will escort you out through a different doorway so that you don't come back through here because there may be something I'm having to take up that you shouldn't hear. So we're going to ask you to step across the hallway and we'll be in recess for about 15 minutes. When you come back, I'm going to give you this detailed set of instructions. So try to stretch your legs until then. So, all right, thank you. You may go.
Yo, turn the beat up in Vaughn's dictionary. We ain't spelling right tonight. Nah, we spelling wrong.
All right, before we break for our break this morning, I've been handed a motion to dismiss that Mr. Vaughn has written out by hand and is filed with, or is filing. I'm going to give it to the clerk to file and I need a copy of it run to give the state. And when we return for the beginning of this trial, I want to deal with that motion to dismiss on the record. So we'll be in recess for about 15 minutes. And then when we come back, the first thing we'll do is deal with Mr. Vaughn's motion to dismiss. Following that, I'm going to give the jury first set of instructions if I do not dismiss the case, obviously. And then we'll start with the evidence, opening statements, and then the evidence. All right, we'll be in recess.
Oh, good Lord. Here we go, people. All right, looks like we're getting rolling. It's going to take a second here.
The courtroom, words all twisted. Sherrick Vaughn speaking like logic got evicted. Mirandarization, boy, that ain't a word. Whole jury laughing like, what did we just heard? Unlogical motions, compellment too. He reiterate nonsense like deja vu. Try to squash, not quash his own case in flames. Even spell check filed the motion saying, bruh, that's lame. It's a moot point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruit the judge, the clerk, and his crew. But the only thing recused was his brain from the view. Dixon, Tennessee, home of bad boy blunders. Vaughn taking L's like it's courtroom thunder. Fired his lawyer, then begged for a hand. Elbow counsel stuck like, bro, this ain't the plan. He's pro se, no way, thinking he's slick. But he's playing Uno while the court plays chess quick. Every motion's a joke, every word's a crime. Even Dr. Seuss said, man, that rhyme don't don't rhyme. Requise, recruise, make up what you choose. But every fake word just adds to your blues. Miranderize this, moat point that. Sherrick Vaughn rap dictionary looking flat. It's a moat point, baby, sinking in the trial. Sherrick Vaughn freestyle, but it's juvenile. Tried to recruise the judge, the clerk, and his crew, but the only thing recused was his brain from the view. Miranderization, unlogical station, compelmination, courtroom clown in rotation.
Okay. I'm happy. We got here. I know this is a mess. I missed the shower scene. I wanted to see the hoe in the shower. But I think Brecken appropriately, buzzed it. Whatever, redacted it so you couldn't see all of it. But that's what happened. But I'm gonna hang here. They're gonna come back in a little bit, and this thing's gonna get going. It should be pretty damn good. Since we have a moment, I have a big shout out for Granddaddy. They played a hell of a show last night. These old dinosaurs are probably my age. Nobody cares. Nobody's heard of Granddaddy. But they sold this thing out. Dahlia Hall. It's a good sized venue. They played all of Software Slump, in case you were wondering. I know you weren't. But damn, they did a good job. Not that they'll ever see this. Not that they'll ever see this, but I give them credit. I give them credit. They were up there and they rocked. They had energy. I wouldn't bother you with this other than I'm killing time. waiting for this thing to start.
All right, grab a White Claw. Settle in today. We got a true legal scholar on the docket, a pro se defendant who's about to teach us all a lesson, though. Probably not the one he intends. A flurry of filings land with a thud. Got a judicial notice to muddy the mud. The judge looks confused by the arrest of judgment. While our pro se scholar files a motion to squash the whole punishment. The state didn't write back. It's a legal disgrace. And without Mirandarization, he's closing the case. He says, Your Honor, the logic is sound and astute. It all stems directly from a poisonous root. He's serving up his tainted fruit. The fruit, the tainted fruits. From a very illegal poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. The state calls their witness Corporal Javin so calm. Yeah. Tales of the threats and the verbal napalm. I'm a threat for a reason. He said with the glare, then a scholar on cross-exam says hold it right there. To prove that this tree has been poisoned for good, let's play my arrest video. It's misunderstood. Oh geez, here we go. He's playing the tape. He's literally handing the prosecution the very fruit he wants thrown out. You hate to see it. No, wait, you love to see it. The body cam rolls a spectacular own. The seeds of his legal demise are now sown. Citing Pennsylvania while refusing for 8 straight times to even get out. When her jaw gets broke, it's gonna be your fault. He's proving the state's case without any halt. He's showing the jury with his own evidence the very fresh fruits of a brand new offense. He's serving up his tainted fruit. The tainted fruit. From a very illegal, poisonous root. This whole damn case you must acquit. Cause it all comes from this tainted shit. Then he calls to the stand his one saving grace, his baby mama to plead his whole case. Tell the jury he asks her if you'd be so kind. Am I the retaliating, threatening kind? She swears on the stand he wouldn't hurt a fly, a claim the prosecutor's quick to deny. Now, ma'am, about that aggravated robbery. He thought to praise his character and opened up the door for the jury to hear of the crimes he'd done before. And the jury comes back guilty, unanimous. He showed them the video of the crime, opened the door to his priors, and based his entire defense on a mispronounced legal theory. He served the jury his own tainted fruits on a silver platter. In the end, it was just a fallacy of a mismalice of justice.
Pulled up slow in my rusted Ford, no tags, no license, just the good Lord. Said I ain't driving, I'm traveling free, but that deputy sure didn't agree. I said this ain't a car, it's a private conveyance. My rights are in place and I don't need no maintenance. He slapped on the cuffs with a Bordeaux look. Now I'm sitting in court with the rule book. Now I don't consent to be here, sir. I stand as a man, not referred to as some legal fiction name. But Judge Mike ain't playing that game. He banged that gavel, leaned in tight, said, son, you're not half right. You can't YouTube your way through law. Then he smiled and read my charge. I said according to the Magna Carta, but he said this ain't medieval Sparta. Tried to cite section codes from my phone, but he asked me to sit down alone. I filed 6 motions in paper and pen, all handwritten with a chicken scratch pen. He said you can write all the fiction you need, but the facts don't care what you believe. Now I don't consent to be here, Judge. I'm flesh and blood, I won't budge. Told him I ain't subject to stay. He just called for a 5-minute break. Came back, laughed and said, all right, friend, you done yet? We're going round again. Told me you're free to act the fool, but you're still in my court and under my rule. Now, son, you can quote TikTok or Jesus, but it won't stop them traffic polices. And driving ain't some holy commandment. It's a license, not a First Amendment. So I paid my fine and took the tests, hung up my theories, gave them a rest. Now I tell folks loud and clear, don't go sovereign if Judge Mike is near.
Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk with Mike is experiencing what we in the business call a plot hole-sized lull. This is, of course, due entirely to Mike's, let's say,
to dismiss The motion states as follows: I, Sherrick Vaughn, affirm that the foregoing is true and the best of my knowledge under the penalty of perjury. I move the courts to dismiss for staleness of the prosecution, maliciousness, and lack of notice. Neither witness or trial was given notice more than 18 hours. This is clear prejudice against the defendant
Staleness.
and threat to justice. My pray to the courts is for dismissal of this court for lack of due diligence, failure to follow notice rule of Tennessee criminal procedure. All right. This is one of the pending cases that has been pending for some time. It is certainly not a new case that's been suddenly brought. It is a case that was one of 4 cases, Mr. Vaughn, that you have had pending in this court. And as a result of that, certainly it is not a surprise or anything that that this case would be suddenly set for trial. When we were in court yesterday, I reminded you that you had filed a motion for speedy trial. And this is a failure to appear, which is not a complex case involving a multitude of discovery issues. It is simply a factual issue as to whether or not you did or did not fail to appear and whether or not there was any justifiable reason for it. And as a result of that, this court granted your motion for a speedy trial and set it for today. And at that point, yesterday, you voiced no opposition to it. And I asked you if you wanted to represent yourself and said, of course. So we are here today only because of the fact that you had requested a speedy trial. We're giving you a speedy trial on this issue. We'll work on the speedy trial for the remaining cases that you have. And but your motion to dismiss is respectfully denied, and we are ready to bring the jury in.
Nope.
Jury, okay. Just hand them to them as they come in.
Ambitious approach to preparation, and by ambitious I mean utterly devoid. Yes, the very fabric of our legal system, as represented by this live stream, has encountered a, shall we say, temporal anomaly. A glitch, a hiccup, a veritable vacuum of action. And who is to blame? Why none other than our esteemed yet
I think Officer Howell may have mentioned that you can sit anywhere you want to now. There's no assigned seating since we have now passed the jury selection. You can spread out a little bit since there's 4 seats on the end. If you want to, it's up to you. All right, we're going to read you the initial charge. Ladies and gentlemen of the jury, the defendant, Sherrick Markey Vaughn, is charged in the indictment with the crime of failure to appear. The defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of these proceedings. I want to basically describe how the trial will be conducted and what the attorneys, jurors, and the judge.
Have you ever had a failure
At the
to
end of the
appear?
trial, I will give you more detailed instructions on how you're to go about reaching your decision, but now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative worth or importance, rather. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant is charged in the indictment with failure to appear. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant had been directed to appear by a lawful authority, having been released from custody with or without bail on condition of subsequent appearance at an official proceeding. at a specified time or place and knowingly failed to appear. The defendant has pled not guilty to the charges. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, and it says an attorney for the defendant, but the defendant representing himself may make an opening statement if he should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dixon County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you've heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you to understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law you are to use in reaching your verdict. After you hear my instructions, I will select and excuse any alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence or to have his attorney or himself acting as attorney make any statements or arguments or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required.
Oh,
and this
thank
certainty
you.
is required as to every element of proof necessary to constitute the offense. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must consider the evidence in each count separately, and you must base your decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify. Then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to the witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of the witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused, and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed By the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon this fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question, or the reason that it could not be asked, please ask after court is adjourned, and I will attempt to explain it to you. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have any personal interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Did the witness seem to have a memory of the events that he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Was the witness distracted in any way? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make up your own evaluation of the testimony given by each of the witnesses and determine what weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You are not required to accept or reject everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness. In making up your mind and reaching a verdict, do not base any decision on the fact that there are more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I decide on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from a ruling on that objection. My rulings relate only to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you're instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or a motion will be based solely upon the law. You must not infer from a ruling that I hold any view or opinion for or against any party in this lawsuit. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is that direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence.
I'm glad you noticed.
circumstantial evidence,
Thank
or
you.
both. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with a paper and pen if you decide to take notes. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. First, do not discuss the case among yourselves during the trial until I instruct you on the law and you start deliberating at the end of the case. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of the case would be premature and improper. Second, during the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. I apologize. Please do not talk with them about any subject whatsoever. You may see them in the hallway or on an elevator or at some other location. If you do, perhaps the best standing rule is not to say anything. Third, do not permit any other person to discuss the case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. I do not know if there will be any media reports in the newspapers, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decisions solely on the evidence you hear in the courtroom.
That and
you may not communicate with anyone or provide any information, photographs, or video to anyone by any means about the case on your cell phone, through email, Android, iPhone, text messaging, video, FaceTime, Google Duo, Zoom, Facebook, Messenger, Skype, through any blog or website, through any internet chat room, or by way of any other social networking websites, including but not limited to MySpace, Facebook, Instagram, Snapchat, Twitter, LinkedIn, TikTok, Meetup, Pinterest, Reddit, and YouTube, especially including the live stream of this trial. In keeping with the state of Tennessee's open access to the court's public policy, the majority of court proceedings are live streamed via YouTube. You as a juror are not recorded on video or shown on camera. You are not permitted to read, watch, or listen to those YouTube streams during the trial. You as jurors must base your decisions solely on the evidence you hear in the courtroom. I will remind you of your duty and responsibility before all breaks in jury out hearings and trust you will follow my instruction in keeping with the integrity of the case and court proceedings. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. For example, do not visit the scene of an incident, read any textbooks or articles concerning any issue in this case, or consult any other source of information.
Judge, I'll remind you of what happened to the last guy that
information
messed
is
with
not
us.
evidence. You must decide this case only on the evidence and law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing, and in some instances, I may ask you to retire to the jury room while we discuss the matter out of your presence. I will try to avoid as many of these interruptions as possible. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, Please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your court officers who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1 for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full undivided attention to this case. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictment in this case. General Bryson.
In the Circuit Court for Dickson County, Tennessee, at Charlotte, September term, Grand Jury 2024. The grand jurors of Dickson County, Tennessee, duly impaneled, sworn, and upon their oaths do present that on or about July 24th, 2024, in Dickson County, Tennessee, and prior to the finding of this indictment, Sharik Marquis Vaughn, then and there, did unlawfully and knowingly fail to appear in the Circuit Court for Dickson County, Charlotte, Tennessee, as directed by the Circuit Court for the purpose of attending an official proceeding, to wit, trial date for docket cases 22 CC 2022 CR 336, 2022 CC 22 CC 2023 CR 227, and 2022 CC 2021 CR 462 in violation of Tennessee Code Annotated 3916-609 and against the peace and dignity of the state of Tennessee. Signed, W. Ray Crouch, Jr., District Attorney General.
Mr. Vaughn, to that indictment, how do you plead?
Not guilty, Your Honor.
Plea of not guilty is entered. The next step will be for the opening statements of the lawyers or of Mr. Vaughn, if you choose to do so. General?
Judge, I'll waive an opening.
Mr. Vaughn, do you wish to make any sort of opening statement?
No, sir.
All right. Opening statements have been waived. Therefore, the state may proceed with its proof. You may call your first witness.
State will call Pam Lewis.
Ms. Lewis, if you'll come forward, please.
Are you Pam Lewis?
Yes, ma'am.
And you are our Dickson County Circuit Court Clerk.
Yes, ma'am.
How long have you served as the Circuit Court Clerk?
Since 2002.
And what is the general duties of a Circuit Court Clerk?
General duties of the Circuit Court Clerk is to maintain the court records.
And either you or your staff are present for all Circuit Court dates?
Yes.
And in this case, we are here, Sharik Marquis Vaughn is on trial, and we're going to be talking about him. Is he here in the courtroom?
Yes, ma'am.
Could you point to him?
He's sitting at the defense table.
Judge, if the record would reflect that she's identified the defendant.
Record will so reflect.
And did the defendant have a trial date set on July the 24th of 2024?
Yes, ma'am.
Okay. And he had 3 cases set for trial that day?
Yes, ma'am.
And when someone has a trial date coming up, how do they know that they have a trial date coming up?
When they come to arraignment, we check to see if they need an attorney, and then they are given a plea date and a trial date.
And what was the date of the immediately preceding court date for the defendant? So when was the last time he was in court before that July 24th trial date?
July 19th.
And that was here in Dickson County?
Yes, it was before Judge Lockard Mash.
And he needed to appear in the same courtroom that on July 19th as he was on July 24th?
Yes, ma'am.
And Was his court date announced on that July 19th date?
Yes.
Now, would he have known about the trial date before that July 19th date?
Yes, he was notified in March of 2024 when Attorney Flanagan filed a motion to withdraw as counsel.
So he was aware of the court date in March and then was in court, let's see, the 19th to the 24th, 5 days before his trial date.
Yes.
Now, on the date of a trial, such as the one scheduled on July 24th of 2024, does your office bring in a jury panel?
Yes, ma'am.
And was a jury panel brought in for this trial?
Yes.
And did the defendant show up for his court date on July the 24th of 2024?
No, ma'am.
And you have reviewed all 3 docket sheets for all 3 cases listed on the indictment?
Yes, ma'am.
And he was not present?
He was not present.
Judge, that's the state's questions for this witness.
Mr. Vaughn, do you have questions you want to ask of this witness?
I do.
All right.
Oh, here we go.
Good morning.
Morning.
Okay. I believe you just stated to Miss Bryson that your job title is to maintain court records.
Yes, sir.
Okay. What type of records are they? Like.
We have criminal records, civil records.
Okay. Okay. Are you biased against me?
No.
You are not?
No.
Okay. Do you recall speaking to, are you familiar with who Scott Tummins is?
Yes, he's a bondsman.
Yes, he's a bondsman. Did you happen to speak to him at the time when I was alleged not to appear?
No, sir.
Okay. I don't have it with me. I have on some of your records. It says that you spoke to Scott Tummins and as well to Lee Spratt. You not recall your record saying that?
No, sir.
Okay. It says that that the copy I have that you spoke to Lee Spratt and Lee Spratt spoke to you and said he had no contact with me.
That was the day of the trial. He announced he had no contact with you.
Okay. Is Lee Spratt my elbow counsel?
He was, yes, sir.
He was my elbow counsel?
Yes, sir.
So he can make statements on my behalf and testify on my behalf?
Yes.
He can, without my lead?
No, not without your permission.
Okay, so he did that free will?
I guess so.
Okay. You said that you keep a record of everything filed into this court. Have I ever filed a complaint against you?
No, sir.
Have I filed any paperwork to have you recused or anything in this court?
Yes, I do believe you did.
Okay, I did. Okay. Was I ever charged with another failure to appear out of this court?
I don't believe so. Not that I remember you haven't been.
One that I back, I want to say last year, and I was released upon out of this court.
Let me think. On July 19th, the day you was here, that Judge Lockard Mash reinstated to your bond. That was the day they dismissed the first one because you gave reason why you did not show up the first time.
Correct.
That was prior to the July 24th.
Correct.
Yes.
And what was the reasoning for that one?
I do not remember what reason you gave.
Could it possibly been some messed up paperwork?
It could have been.
Okay. What about this time? Do you think that could have possibly been?
No, sir. No, sir.
Your Honor, that's all.
Redirect.
No, Judge.
Thank you, Ms. Lewis. You may step down. May she resume her duties if she wants to. You want her at the table with you. Go back to the table and have a seat. State may call your next witness.
Judge, that will be the state's case in chief.
State has rested their proof, Mr. Vaughn. Ladies and gentlemen, if you'll step across the hallway for a moment, let me take up one matter.
Did you just excuse the jury?
All right, Mr. Vaughn, if you'll come to the podium, please. Mr. Vaughn, the state has rested their proof, so the next question is whether or not you want to present any proof. I want to go through your rights as a defendant to make sure you understand what your options are. We did this at the last trial, so I'm sure you're familiar with it. But I'm going to ask you to raise your right hand and let me place you under oath for the sole purpose of this examination. All right.
Fine.
Mr. Vaughn, you are representing yourself, but even as a defendant representing yourself, you have the right to testify at a trial, at this trial. And if you choose to testify, then no one can stop you from testifying if you want to give your version of the events.
Please do.
Likewise, you are not required to testify, and no inference of guilt will arise if you choose not to testify. No one can make you testify if you don't want to testify. So the question becomes, do you wish to testify at your trial, or do you want to waive your right to testify?
I'll waive it.
You're going to waive your right to testify?
Oh.
Yes, sir.
All right, then have a seat. Bring the
Too
jury
bad.
back.
I wanted him to eat his convictions. And I wanted to hear his stupid.
I'm sorry. Okay. All right, ladies and gentlemen, the state has now rested. Mr. Vaughn, you as the defense have the right to present proof. Do you wish to put on any proof?
No, sir.
All right, then the state has rested, the defense has rested, so you will now hear if there's any closing arguments that the sides wish to make, then you will hear from them.
Ladies and gentlemen, this is probably the shortest jury trial that has happened in this courtroom. It's okay, you don't have to. The defendant is charged with failing to appear on his trial date, July 24th of 2024. You have heard testimony that he was in this courtroom on July 19th, just a few days before that, where he would have known of his court date, and that just a few days later, he failed to appear for that court date. And as such, the state will ask you, you're going to receive instructions from the judge and a jury verdict. You'll go back and elect a foreman, and the state will ask you to return a guilty verdict for failure to appear. Thank you.
Mr. Vaughn, you have the right to address the jury, but you may not testify. You may only argue about the facts.
You just heard me ask the witness multiple questions about whether she was biased and whether I filed a complaint against her. She testified that I have. You've also heard that I've been charged with failure to appear at this court before too, and it was also dismissed. You've also heard that I've asked the witness whether there has been errors made before in my case, and you also heard her state yes. I'm asking y'all to take this and do the best y'all can. Thank y'all.
State has the final say if you wish.
Judge, I'll waive.
All right, and ladies and gentlemen, we have a final set of instructions to give to you. All right, ladies and gentlemen, this will be the final charge of the court. The defendant, Sheriff Marky Vaughn, is charged in the indictment with the crime of failure to appear. The defendant pleads not guilty to the indictment and the offense contained therein. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability, after such investigation, to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Dickson County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Dickson County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. As heretofore stated in the indictment, the defendant is charged with the crime of failure to appear. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly failed to appear, and 2, that the defendant had been directed to appear by a lawful authority, and 3, that the defendant had been released from custody with or without bail on condition of subsequent appearance at an official proceeding at a specified time or place. Custody means under arrest by a law enforcement officer or under restraint by a public servant pursuant to an order of a court. Official proceeding means any type of administrative, executive, legislative, or judicial proceeding that may be conducted before a public servant authorized by law to take statements under oath. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find the defendant guilty of a failure to appear as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreman or forelady will announce it. In reaching your verdict, you shall consider the offense
Because of the
charged in
Constitution.
indictment. If you unanimously find the defendant guilty of the offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to the defendant. On the other hand, if you do not find the state if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. If after your deliberations you find the defendant guilty, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. You may now retire to begin your deliberations. Ladies and gentlemen, I have prepared a verdict form that will go back with the original of the charge, and it simply finds a place. It just provides that in the indictment for the charge of failure to appear, we, the jury, find the defendant, Sherrick Markey Vaughn, either not guilty or guilty, and you check one and the foreman signs it. So, ladies and gentlemen, if you will step across the hallway, you may begin your deliberation. This will go back with it.
Yeah, I think he's got a couple more out there.
Right. While we were here, General, we have discussed trying to conduct another one of Mr. Vaughn's trials on the 23rd and 24th of this month.
Oh, here we go.
Yes, Judge. One of my victim witness coordinators is calling this morning to all of the witnesses in the simple assault case to confirm their availability for that trial. I've not had a chance to see if she's got in touch with everyone.
As soon as you know anything, if you can find out before we are adjourned today, I would appreciate those. Mr. Vaughn needs to know if he's going to trial on the 23rd and 24th.
Is my witness still to need to be subpoenaed for
Which
that?
witness is that?
Jennifer Dozier. I placed in a motion for her to be at every one of them, every pending case.
I don't know. We need to make sure that Ms. Dozier was subpoenaed for this trial, the next trial. Problem is we don't have a trial date, so it's hard to subpoena somebody to let them know they have to be somewhere when we don't know what the trial date is. But there should be a subpoena issued for her. Is she still in Savannah?
Yes.
All right. All right, Mr. Vaughn, if you'll step back with the officers, we'll bring you out when the jury is returned.
I have a quick question, if I could, Your Honor. This is about yesterday, if I can just gain some clarity.
All right.
I haven't had the chance to go through that paperwork yet. Was a transcript in that paperwork?
A transcript of what?
Of the proceedings. Was that in that
Are
paperwork?
you talking about a typewritten transcript?
Yes, sir.
No, that was not provided. What was provided was the entirety of your file here in the court. As far as if you're asking for a transcript of every time you appeared in court, that will be a lengthy procedure to have to identify what days we're talking about. Then the court reporter would have to have a sufficient length of time to type everything up, which will be a very difficult thing for her to do on a short-term situation. So. Okay. So there's an order granting you a transcript, but you don't have it yet.
For which days, Your Honor?
Well,
All right, thank you, Your Honor.
Just seeking a little clarity. He is in custody. They let him get dressed today, but yesterday he was in Orange.
thank you. Thank you. Okay.
Literally more happened in the court appearance yesterday preparing for trial than this.
Take a recess until the jury returns.
All right. Let me see here. I've got one. I've got one queued up from Zach for this very occasion. I'll be monitoring as soon as I hear. We'll come back.
Just had time to confer with Mr. Soto Escalera. Any further evidence from the defense?
Well, Judge, I did have some commentary to make and some argument to make. However,
Right. But outside of argument?
No more. Well, Mr. Soto Escalera wants to speak, Judge. I do believe.
Okay.
My client would like to address.
Okay, he may make a statement either under oath or not under oath at his choosing, elocution or otherwise. Okay, you may make a statement, Mr. Soto Escalera, at this time. Go ahead.
Thank you, sir. What I'm bringing to the courts to address is I have a conflict of interest. Mr. Vaughn. But I was asking for your permission, if possible, if I can get him removed from my case because I don't trust him.
Mr. Soto Escalera, trying to think of how to say this in a way that's most understandable. I think there's an expression, we're at the 11th hour. But this is probably even beyond that. We're probably at 11:59 here. We're about to close all of the evidence in your case, which would be submitted to me with the jury's recommendation, whether you should receive the death penalty or life in prison. Counsel has already done his job. They've already completed their work on the case. Really, at this point, all that's left for them to do is argue to me. So I don't believe there's really any purpose in that at this time. Even if I were to grant your request, there's nothing left for counsel to do at this time other than to make argument to me, which quite frankly could be persuasive, but given the judge's function where we are, as I mentioned, 11:59 metaphorically, there's really not much purpose in that. So from counsel, since it does affect counsel, does counsel agree with my observation on that particular point? I'm going to inquire Mr. Soto Escalera whether he wants to speak about the decision I have to make and give me input in that regard, because he has the right to do that. But that's separate and apart from what's being said now. Does counsel for the defense agree with my observation as far as, if this is a request to discharge counsel where
Absolutely, judging that.
the horse is out of the barn at 11:59 p.m., I suppose would be the metaphorical.
Correct. As I explained to my client, I am not qualified to be on the case by myself because I'm all second share qualified. So Mr. Burns has to remain on the case to the duration.
Right. And just for the record, I haven't heard the arguments yet, but there's been a substantial amount of mitigation put before me, both at the trial and additionally here today, that I have to consider and digest. And does not seem to me that there's any reason for me to discharge counsel at this time. More importantly, before you brought that up, Mr. Soto Escalera, you do have the right to make a statement at this time, either under oath or otherwise, that I would consider in making my determination in this sentencing proceeding. You understand you have that right to do that. Yes. And I was assuming that you were going to do that. I'm not saying whether you should or not. That's between you and your counsel. But I want to make sure that by me dismissing your conflict of interest issue, you don't take that as me dismissing your ability to make such a statement. Do you wish to make such a statement, or do you wish to talk to your counsel about whether you wish to do that at this time?
The only reason why I brought it up, Your Honor, is because something has surfaced with a witness, and it was recorded in audio. This is why I'm requesting that I would have him removed. But if I can't remove him, I would like you to see what I'm speaking about him, so you can understand what I'm trying to say, if you have the time, Your Honor.
With regard to that, that would be a decision in this very important context for your attorneys to make, whether to submit that issue to me as far as potential mitigation. And I would, as I'm required to do, I would defer to their professional decision in that regard.
Enough, Judge. I'm going to lay it all out on the record, okay? I think Mr. Soto Escalera is hurting his situation. He's proceeding rigorous on the advice of ignorant people. What he is referring to is a Zoom recorded deposition, the first such deposition I ever did in my life, with witness Lucinda Cook. This was done, I think, on the Tuesday when there was a court holiday, when we were in the midst of trial or jury selection. I'm not sure exactly where we were yet. And before...
Oh, I haven't seen this before, but this attorney's had enough. Oh, this is fun.
Ms. Cook joined. There was a recording with chit-chat between me and Mr. Richardson about witnesses in the case, about the state of the case, about why I was calling witnesses and not calling witnesses, and complaining about somebody who had Ms. Minton's credit card and was going over the limits, and chit-chatting as counsel do between themselves waiting for a witness. And I don't think people understand the context of how attorneys talk to each other. I think that the witnesses who overheard this, Ms. Lucinda Cook and whoever else she communicated with, think that because this is a capital murder case, me and Mr. Richardson should be like this with our hands around each other's throats every moment. And we were not that way. We were chatting as counsel do in the case. And in a capital case especially, do counsel and adversaries have to communicate frequently and exhaustively to get the thing from start to finish done. That's all that it was. There is nothing in there that was inimical to Mr. Jose Soto Escalera's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case or in the trial or in the penalty phase that was contrary to his interest. It's nonsense and bullcrap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot on this issue, at least.
In that regard, for Mr. Soto Escalera's benefit, and the people who are here observing this proceeding, regardless of the court's sentencing decision, whether I impose a life sentence or a death sentence, there are appeals that take place directly and then indirect appeals which relate to assistance of counsel, whether the defendant received proper assistance of counsel. That's for a different day. I could see this coming up perhaps in that scenario on the merits to be figured out at that time as appropriate, which goes back to what I said before. The evidence is in. Mitigation has been placed before me. So we're at that stage where I'm to consider that. Put differently, if Mr. Soto Escalera feels that Mr. Burns did not properly litigate his case for whatever reason, there will be a proceeding in that regard. But to be fair to Mr. Burns' respected counsel before the court, usually what has to be shown, or what would have to be shown, is something of substance, not just some idle remark we see from criminal defendants all the time, like, my attorney is working for the state, because look, they're smiling at each other and they're acting as professionals and not constantly cursing and berating each other and putting each other down. That's not the expectation of the court.
Right hand. Show that all jurors have signified that this is a unanimous verdict. Thank you, ladies and gentlemen. We're going to dismiss you now, but thank you for your time and attention.
Oops. I said it was muted. We missed it. It came back so fast that I had it, and as soon as I heard it, I clicked over, but it took 20 seconds, and that's how fast it was for them to do it. I'm shocked. The jury had so many issues to wrestle with here. Like, for instance, was he there or not there? And other things. No, there were no other things. Oh, I got it right here.
All right, ladies and gentlemen, I'm told that you have reached a verdict. Is that correct? Will the foreman please stand and announce as to the indictment, the charge of failure to appear, how does the jury find the defendant? Guilty or not guilty? All right. Is this the unanimous verdict of all, if you will, signify by raising your right hand? Show that all jurors have signified that this is a unanimous verdict. Thank you, ladies and gentlemen. We're going to dismiss you now, but thank you for your time and attention. As I explained to you, every person has a constitutional right to try a case that they're charged with.
I didn't hear it.
If it involves any type of incarceration. So the fact that Mr. Vaughn tried this case today just means he was exercising a constitutional right that we give every defendant. Thank you for your time and attention, and we're going to allow you to be discharged. I wish I could tell you don't have to answer the call the next time, but we need you to check that number after 6 p.m. on the 22nd for possible service on the 23rd. And you may free to go. If you'll exit through this door, there's another exit they can let you. If there's anything you have that you need to get out of the jury room, please do so. Thank you.
I mean, I can't imagine that it wasn't guilty, but I didn't hear it. And I didn't hear the judge announce it as guilty.
All right. We have set a sentencing hearing on Mr. Vaughn's other charges on January the 28th, so this case will also be combined for sentencing on that charge as well.
Well, there we go. There's my first
And
confirmation.
we are trying to determine whether or not it's possible to try one of his other cases on the 23rd, and I assume you're going to have to check and.
I mean, you wouldn't set it for sentencing if it was not guilty, right? So it's guilty.
All right. Let us know as quickly as possible. Mr. Vaughn, we'll get word to you at the jail as quickly as possible once we know that the trial on the 23rd is going to go forward. So that will be for the simple assault.
Yes, Judge.
Would that be like, you gonna send me a letter or something?
Actually, I think, yes, they'll have to send you a notice at the jail from, where are you housed, in Decatur?
No, I'm here.
He's here.
I've been here.
Judge, I will, I normally, when I'm dealing with an attorney, I normally copy that attorney on my email to the clerk for my witness list. And so I will write Mr. Vaughn a letter confirming and giving him a formal witness list.
Okay.
All right.
All right, so we have, right now, as far as the cases that remain of Mr. Vaughn, we have two more indictments, is
Well,
that correct?
we'll still have to go back and try the driving on revoked.
Well, we could do that on the 23rd, if nothing else, couldn't we?
Yes, Judge, I should be able to do that. I'll check with Officer Javen.
That's the driving on revoked third offense.
That's the one where he withdrew his plea.
I was allowed him to withdraw his guilty plea.
Yes, Judge. And, I mean, I could probably try those. I mean, if I try one on the 23rd, I can try the other one on the 24th.
I think that would be a good plan. So, all right. Then we'll let you know as soon as possible, Mr. Vaughn, whether we're going to be trying.
We're gonna have 2 more jury trials.
We can expect to try at least one of those cases, the driving on revoked license, on the 23rd or 24th, depending on one of those 2 days. Just expect you're going to go forward on your driving on revoked license that I allowed you to withdraw your plea on, and that will take place. We'll need to make sure that it's a separate jury panel. So. Correct. All right. Mr. Vaughn will be remanded to the jail until his next trial date. We stand adjourned.
I wanted to see him get cuffed again. Well, there you have it. We got the whole jury trial in. We had some whole fun, and then we got a jury trial in. All in about 2 hours. I mean, we're getting it done here at Law Talk with Mike. And we got 2 more coming up. These trials are so stupid. The judge is just trying to slap them all together so that he can sentence them all at the same time, which makes sense for judicial economy. But yeah, I mean, you got a right to a jury trial. If it demands a jury trial, you get juries on it. Even after that, I mean, can you imagine the trial for driving revoked is the same thing? I mean, I guess it's a little more complicated. You got to prove he was driving, and then you got to prove that he didn't have a license at the time. There's 2 things. I guess you had to prove 2 things here too. One, that he was supposed to, it was a condition of his it was a condition of the court order that he show up to court on that date, and 2, that he didn't show up. And that's that. Oh, it's a lot of fun. It's a lot of fun. We did. He was better today. He did some smarter things like not testify. His language, he didn't make up any. I don't think he made up any new words today, but that's just because he spoke so little. Give him an opportunity. Although when he did come up there, like, I'm seeking clarity, which is it's just dopey speak, It's like this therapeutic BS. Just that turn of phrase for it. Just anyway, there we go. Another big fat L for our man. Another L. It was fun. We're gonna have some more entertainment. He's gonna have one hell of a playlist before this is over. For now, it's all sitting over there on Judge Wolf's playlist. But I think I'm gonna have to make another one just for his cases, because at this point I probably have 5 or 6 just his appearances, and they're pretty good. They're pretty good. And this one even started with little hoe fun. So there you go. That's a bonus. Thank y'all for coming out. I appreciate it.